Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, I'm going to briefly discuss the issue of so-called advanced parole from the United States with respect to the K-1 fiancé visa. What are we talking about here? Well, specifically, the K-1 visa is something of a unique visa insofar as, first of all, it's a dual intent visa. So it's not only, it's issued under the non-immigrant visa category, but it maintains an immigrant intent because the holder of a K-1 visa will travel to the United States, and within 90 days of their arrival in the United States, they need to marry their fiancé and apply for adjustment of status to permanent residence in the USA. Now, the world has problems. Life is a complex thing. And sometimes what will happen is someone will go to the United States in K-1 status, and let's say a relative back in Thailand gets sick, or there's some kind of massive emergency or some requirement that may not even reach quite the level of emergency, but simply the fiancé needs to leave the USA. Well, the problem with leaving USA on K-1, if one has not adjusted to permanent residence, is the fact that by leaving, essentially, that visa is dead. And one would either need to reapply for a new visa or would have to, if the individual is already married, an entirely new petition may need to be filed with respect to the applicant. There's a way to deal with this and to forestall this, for lack of a better term, cancellation upon exiting the United States. And the way that this is often dealt with is called advanced parole. And basically what happens is the United States government, the immigration authorities, Department of Homeland Security, is petitioned and told, hey, look, this individual is in K-1 status. They're in the process of adjusting to permanent residence, but something has come up and they need to leave. If advanced parole is approved, and it's not necessarily always approved, but if it is approved, then the individual can leave the United States and effectively their status in the United States is maintained. It's very, very similar in a lot of ways to a re-entry permit, both in the United States and in Thailand, in the sense that the underlying visa status is, for lack of a better term, frozen, and that individual can then return on their advanced parole documents in order to sort of re-uptake the processing of their case. Failure to get advanced parole could have serious implications for a K-1 visa holder because it could result in a loss of the visa, and in certain instances the loss of that visa can be rectified somewhat quickly, but in other instances it may be impossible to rectify the situation, especially if there have been material changes to the applicant's overall situation. This can have a significant impact on their personal life because, again, it could take months more to reprocess a new case, and it could have a lot of costs with respect to time and resources. So if an individual is in the United States on a K-1 and is pending or maybe not yet pending adjustment, it is imperative to do one's research before leaving the United States, as doing so could have, for lack of a better term, and not to sound not hyperbole, like it could have dire consequences in an immigration sense. Because it might not be possible to re-enter the United States for a significant period of time if further processing of an entire case is necessary.